the District of Columbia Federal Court of Appeals issued an order in General Flynn's case. If you remember, the issue there is a writ of mandamus that was filed by General Flynn through his lawyer, Sidney Powell, who's done a fantastic job in this case. I can't say that enough. And she asked for a writ of mandamus to not allow this judge to basically appoint this amicus curiae, which is basically now a special prosecutor, to continue to go after Flynn after the Department of Justice said we're done with the case. So the D.C. Court of Appeals yesterday issued this order. I'm going to read it to you. It says, upon consideration of the emergency petition for a writ of mandamus, it is ordered on the court's own motion that within 10 days of the date of this order, the district judge file a response addressing the petitioner's request that this court order the district judge to grant the government's motion to dismiss filed on May 7th, 2020. The government was also invited to respond within their discretion.
In my view, a slap in the face to the district judge telling him, what are you doing? When the defendant asks the case to be dismissed and the government concurs in that and says the prosecution should terminate, who are you to appoint a referee to come in and assist you in making a decision on something that Federal Rule 28 of the Rules of Criminal Procedure says you have to do ministerially? I think it's a humiliating blow. It was done very tactfully. I agree with the comment that was made at the opening. It was done in an attempt to save face. They did not name the district judge. They could have said Judge Emmett Sullivan. And it was unanimous, Jay. It was a 3-judge panel of the D.C. Circuit that unanimously agreed. The D.C. Circuit could have said, I don't want to hear any more. Dismiss this case. But they said to him, you got 10 days to explain yourself. And that in and of itself, to me, is a humiliation to a judge who served for 25 years?
What is motivating Judge Sullivan to continue this case when you have the district court judge entering his initial order appointing this amicus curiae? Then you have the situation where you had the Department of Justice say, you know what, we agree that the motion to withdraw the plea should be withdrawn because we think there was misconduct sufficient enough that there was not cause to make a prosecution here.
They issued a very succinct order saying you've got to file a response by June 1. I mean, usually they invite a response from the judge, but here they're ordering a response from Judge Sullivan. They cite Fokker Services and Rule 48A, which require him to accept the government's dismissal. I mean, it says with leave of court, but that's a purely ministerial section to provide that the defendant cannot be punished repeatedly by multiple prosecutions, which wouldn't apply here because the government wants to dismiss it with prejudice, as they should.
Justice Ginsburg, for a unanimous Supreme Court, 9-0, said that the parties are the one who litigate the cases and issues. Judges don't intervene and appoint people to do things that are not within the scope of the Article 3 responsibilities of what judges are appointed to do under the Constitution.
The reason that Judge Gleeson in the Article 3 branch does not have that power, it's not just arbitrary, Jay. It's because they are not directly accountable to the voters. They are nominated by the head of by the Article 2 branch, the President of the United States.
It's an extraordinary order based on an extraordinary writ. And it's telling, and to just say what Stan was saying, it's telling an Article 3 judge under our Constitution, you stay within your limits.